Eichmann.
Thank you, Chief Justice, Justices. Good morning. It's a privilege to be here today, given all the circumstances. My colleague, Mr. Lacey, is joining us, but not in person. He's joining us via Zoom. He's in New Brunswick, and he is with us today. Justices, it was December 13th, 2013, almost 7 years ago, when Sergeant Jamie Clark, Detective Sergeant Stevie Watt, and Detective Sergeant Donald Belanger woke up to read the nightmare headlines and accompanying news stories in all the newspapers and electronic media with respect to the Ontario Court of Appeal decision that had been released the day before in the case of R versus Singh. A decision where the newspaper headline refers to them as torturers. A copy of that article is part of our compendium. I'm not going to go through it, but it was one of many articles. And it quotes the three-judge panel that Canadian society cannot tolerate. The courts can't permit police officers to beat subjects in order to obtain confessions. Yet, sadly, that's precisely what happened in this case. One of the two police officers who participated in the beatings apparently thought, as he said, it's part of his job. And then it quotes the defense lawyer saying he was delighted by the remarkable ruling. And remarkable indeed, because as pleaded in the statement of claim, it was totally false. It was fabricated. The accused, for all intents and purposes, had perpetrated a fraud on the courts. I, of course, am going to go into my submissions with respect to all of the policy aspects, especially as discussed this morning. The concern of litigation floodgates, the chilling effects. However, in my submission, to fully understand and properly determine these issues, I would ask the indulgence now to step back a bit and go through some of the material facts as pleaded, and indeed with respect to the various documents that are before the court with respect to those material facts, because this is, again, a Rule 21 motion. You know, sometimes we forget about this, go through these cases. We have no defense. We talked this morning, and I'll get into it, about what the Crown, the appeal Crown, may have been thinking at that moment in time. All speculative at this point, of course. But the material facts, as pleaded, are deemed to be proven or true, and the claim incorporates by reference any document pleaded. And indeed, those transcripts are crucial, because it's my submission that the unique and exceptional factual matrix here that gives rise to this claim will clearly show that this is not in relation at all to any poor discretionary decision. It's not about judgment calls. It's not about subpar performance by a Crown attorney. It doesn't relate, in our respectful submission, to any prosecutorial discretion. It's the conduct which speaks to the prosecutors in question and the Crown Law Office acting outside their office. Doing so motivated by bad faith / malice, and I'm going to get to that. And the issue...
You might want to make sure you get to that. Don't spend all your... I mean, it's your call how you want to do this, but if you get too bogged down in the facts to the points that, at least speaking for myself, I'm interested in.
Mr. Honigman, if I could ask you too, when you're reciting the facts, it would help me to have in my head what you say the legally protected rights of your clients are, and any duties that you say the Crown Attorney owes to them.
Thank you. And I'm going to get to both of those. And thank you, Justice Brown. I'm going to ensure that I don't get bogged down. I just want to take the court to the two important aspects of the facts, and that is the appearances before Justice Thornburn with respect to the trial Crown, and then the appearances before the Court of Appeal in the appeal crown. Because when we talk about the actions and we go to the constituent elements of the tort, and we talk about what we are saying occurred along the way, we don't, in our submission, you don't parse out each fact. My friend said, oh, well, this is a negligence claim dressed up as a misfeasance claim. Where the final, if I could just use the metaphor, the piece of the misfeasance puzzle comes in and locks it down in our respectful submission for the purposes of this motion, are the appearances before the courts by both of those Crown attorneys. Because as pled, and that's the important part of the facts, the trial Crown, at the time that she appears before Justice Thorburn, has, as we set out in the pleadings, various documentation with respect to, and again, I don't, to take Justice Brown's advice, I won't go to each particular paragraph in our pleading, but we set out what she had or what she should have known or ought to have known at the time that she appears in court. And most importantly, she has and she knows that these officers at the preliminary hearing denied under oath any allegation that they beat or assaulted the two accused. She knew that. She knew going into that was, and then Maharaj, the first accused, there wasn't even, there was, the charges were stayed there. There was no further trial. But then going into the Singh case, not only did she know that the officers had denied these allegations under oath at a preliminary hearing, as the claim sets out in the material facts, she had met with Detective Sergeant Watt, who advised her about the fact that they didn't assault these people at all, and that he understood, as set out in the claim, that they would be able to testify to this. That doesn't happen. And so these are the two portions that I just want to ensure that the court has. So the relevant portion of the transcript with respect to the appearance before Justice Thorburn is at tab 2 of our compendium. And why are these appearances important? Because it's going to go to the issue and the questions that were asked. That when a judicial officer is asking a specific question to a Crown attorney, because both Justice Thorburn and the 3 justices of the Court of Appeal, as you will see in the transcript, were very troubled, not just by the alleged conduct of the officers, but what do the alleged officers say about this? And the trial Crown is asked by Justice Thorburn, at page 32, is there any sort of suggestion that this may have come up in any other way? This is talking about suffering at the hands of the police. The trial Crown answers, there's no evidence that it occurred in any other way, and I don't wish to speculate on what happened, because we don't have any evidence before the court about that, other than what Mr. Maharaj has testified to. That's what the trial Crown is submitting in front of Justice Thorburn. And given the strength of the evidence that was presented of the Crown, he would have met his onus in establishing his charter rights had been breached, and given the seriousness of his injuries, we have weighed more strongly in favor of a stay. And the court, understandably so, begins asking questions about what happened. On page 33, trial Crown says, I don't wish to speculate on what happened. It was primarily Officer Clark. And again, nothing from The trial crown at that point, and here's the other important point that I wish to say, because it's going to be very relevant as well with respect to the appeal crown. These questions from the bench, these questions that may, to use your words, Justice Moldaver this morning, put a Crown attorney at that moment in time stuck between a rock and a hard place. In my respectful submission, they shouldn't be between that rock and a hard place, because they would know things beforehand. That's the point.
But, and just to kind of pull you now to Justice Abella's question, right? You say that in that circumstance, your clients are owed, well, your clients have a right to, I'll just genericize it, to have a prosecutor, a Crown prosecutor, take account of their interests in deciding how to proceed. And of course, I think that's a fair sort of summary of what you're saying. And you'll correct me if not. And that right, of course, to be legally cognizable must correspond to a duty. And that duty, like every other duty that we recognize, must be sourced in the law or a law. And so what do you say is the source of the duty that the Crown owed at that point? What law grounds that duty?
Well, and again, going back, and I was going to touch upon, because my friend Mr. Cavalluzzo talked about them not being a police officer, not being a member of the public. They are, at that point in time, with respect to the tort, they are like a member of public, no different. And the decisions by this Crown, or the Crowns, and that we say are tantamount to bad faith, maliciously made for whatever improper purpose, they are now going to be suffering damages from it. The damages are the crucial part of this. It's not just some type of, well, they weren't thinking about us, and therefore, and I'm going to get to how the administration of justice is put in disrepute. There's no doubt about it. But the key part about this is that there's damages, because
but the fact of damages isn't a basis for a finding of a duty. We've never said that.
No.
So what is there has to be unlawful conduct here that constitutes the breach of a duty. So what is the law that was effectively not observed or broken, thereby giving rise to breach of duty? You plead the Crown Attorneys Act.
Well, yes, there's statute that talks about how a Crown attorney is to act, and we plead that. But Justice Brown, I think it's important, because
do you rely on that statute as the source of the duty?
As part of it, we think.
What part of the statute do you rely on?
Well, if I can, and I was going to, and I know you didn't want me to get off my game here at this point. I will go to that, and I'll get back to that in a moment.
Okay.
But what I wanted to say, what I just wanted to make sure I put before the court here, is that, and I don't want it to be lost, is that when a Crown law officer is faced with allegations that the investigating officers have, for all intents and purposes, assaulted, beat, got involved in egregious conduct, and those officers have advised those Crowns that that did not happen, and a Crown law officer says, well, thanks for that, but we don't care, without understanding, and in our respectful submission, should know at that point, about the damages that are going to ensue to those officers based on that decision. And if that decision is made as alleged in bad faith or maliciously for an improper purpose, and those are the key words.
Well, you said earlier for whatever purpose, not improper. You said maliciously and made for whatever purpose.
Sorry, and I have to correct myself.
Right.
Whatever improper purpose. And that's what's pled in the statement. Pleaded.
Where do you plead that?
Well, if we go to the statement of claim, which is found at tab 1 of the compendium. And when you look at the statement of claim, of course, you look at it in its totality. And when we set out the facts with respect to the trial crown, and those facts are set out beginning at paragraph 13, and we take the position at paragraph 18 that the Crown had all of these other facts that they knew about. They never did anything to properly investigate it. They called no evidence, paragraph 20, to challenge or contradict it. And at paragraph 47, we said the deliberate and unlawful conduct, clearly in contravention of their sworn statutory duty. Deliberate and unlawful conduct was not limited to the following. And in our respectful submission, the deliberate unlawful conduct that would be tantamount to bad faith is the improper conduct. And you can't
Lawful conduct, I asked you that earlier. What is the source of the law that says they can't do what they say you did?
The unlawful conduct in our submission, as set out, is not only not properly ascertaining the veracity of the allegations that were brought forward, but then, as that final piece, misrepresenting the issues before the court.
When you mention misrepresenting, is that misleading the court? Because when I look at paragraph, page 37 of the transcript, tab 2 of your book, the court is very sensitive to those issues. The court says, what do I do with the fact that none of these officers testified? And that Mrs. Crespin says, I have Mr. Singh's, what it means, testimony, maybe I believe him, maybe I don't. The court says, but if there were some officers who would said, well, we know nothing, I'm sorry, I talked to him, and so on and so forth. And Ms. Crespin says, well, the Crown did not call anyone. The court says, well, yes. And Ms. Crespin says, and what that means is that the evidence is uncontradicted, other than your honor, of course, is accepting that evidence, so on and so forth.
Right.
Is that misleading the court? And if it is that unlawful?
Yes. In both, my answer is both. Yes to both of those questions. Because that's what I was referring to earlier, Chief Justice, when I said that in both cases, both at the trial and at the appeal, these are direct questions from the bench as to what was said, what were the, and it's very important, that passage. What do I do with the fact that none of these officers testified? And that's a court asking, what do they have to say about this? Do they have anything? And that's the next passage from Justice Thorburn that you read. That you read. And quote, I tapped him on the shoulder. I should never have tapped him on the shoulder. And this is terrible. No.